Hey everyone, Harry here to talk about the big hammer of receivership coming down, bam, on Rudy Giuliani. All right, there's an opinion that has just been issued by Judge Liman. Asterisk. I've known him for many years, clerked with him. He is extremely well respected. And I think as messy as this case is, a court of appeals having a solid opinion below is not going to be looking to mess with it. So I see Giuliani's chances of sort of doing anything to get out from under this as being small. Okay, so what happened? You have now finally, the judgment has gone against him and, by the way, his son who intervened. And the plaintiffs in the case say, look, he's got all this personal and real property, and we want it just transferred to us. We want to take possession of it and sell it or not. Enough funny business. It's time now to actually take this stuff and give it over. All right. So there are two residents in question. One is a luxury co-op on Madison Avenue. One is a mansion of sorts down in Florida. Besides that, there's a claim for a few $1 million in unpaid legal fees that the Trump organization ostensibly owes Giuliani. And besides that, there's all this personal property, much of which he claims has special sentimental value, World Series rings, and the like. So the bottom line is Judge Liman says, right now, within 7 days, your interest in your Madison Avenue co-op is going to be put into receivership under the control of Moss and Freeman. That's it. 7 days, you lose your any kind of interest in this property. Boom, that's done. On the Florida property, Judge Liman does nothing for now. There's going to be a hearing next Monday where he'll maybe analyze it further. Giuliani is trying to use it to protect it under Florida law and a so-called homestead exemption, which says you can't come after someone's primary property. That much they are left even after bankruptcy. There's a big factual dispute about whether that's what this is, however, whether the Florida mansion is his primary residence, and there's an argument that Moss and Freeman are making that it's not his primary residence, rather it's the one in New York. But there's a separate action there, and he's going to hold off. Okay, so Liman starts right out. Plaintiffs are judgment creditors. He owes them $145 million with interest rate at 5%, along with costs, attorney's fees, etc. He recites some of the really labyrinthine procedural history that Giuliani has made Moss and Freeman go through, largely by being completely uncooperative, not telling anything about his assets and the like, even though he was ordered to. And so finally, they got a judgment after the bankruptcy petition was dismissed. It's a piece of paper that says he owes us this amount of money, and you go around and file it in different states. Under the Constitution, states have to give full faith and credit to judgments from other states. So Moss and Freeman been going around the country and saying, hello, Mr. Florida Sheriff or Ms. Florida Sheriff. Here's a piece of paper that says this guy who's got a mansion down there owes me $450 million. Don't do anything with this mansion of his for now. And likewise goes to New York and says, I have an interest in all these things. So Liman's order here is just based on New York law and execution of judgment. Remember, he tried for the protection of bankruptcy, and for a lot of reasons, he then dissolved it. So really, these are just guys who are saying we were in court in New York. here's a piece of paper. We won this much money. Here's a piece of paper that says we do. Under New York law, please enforce it. And that means, this is a real sort of legal little asterisk, but Judge Liman here is applying New York law because it's a case involving diversity. Moss and Freeman, the plaintiffs from Georgia, Giuliani from New York. That's why you can have this case in federal court in so-called diversity jurisdiction. But the main thing is you have this great federal judge in federal court, but applying New York law. So he does. The New York law in question lets a judgment creditor, which is what they are, go to a court and say, just give this to me, or give it directly to the sheriff, and the sheriff will sell it. And whatever money is left over, if it's not enough to pay me, I'll take it all. And if it's more than enough, give me what I need, and you can give the best back to him. So Liman applies this law, but he specifically talks about the modification under New York law, saying that he can just order. You can give it to a sheriff, but you can also just order the turnover of this property to a receiver, and the receiver can then sell any of it, specify the property to be received, etc. And that's what he does. He goes through the factors about when you can appoint a receiver. It's not a common device in New York or elsewhere, but among other things, if a private sale is going to bring a lot more than a sheriff's auction would do, that's one reason you can do it. It's almost a law and economics principle of trying to be efficient. And that's what Liman does. He says, look, Giuliani doesn't challenge the notice given to him. He doesn't challenge that he has ownership interest in these things. Setting aside the World Series rings for a moment, Liman is a baseball fan, by the way. The question is whether to order the receivership of the Palm Beach condo and then all the other personal and real property. And I've told you already, on the condo, that will come for another day. But everything else, turnover and receivership, in order to ensure that the liquidation of the transferred assets is accomplished quickly and consistently by the plaintiff's chosen counsel, maximizing the sale value of these intangible items. Otherwise, especially given Giuliani's record, they would have the unacceptable risk of more delay, or that he would spend into insolvency, which he has certainly given signs of doing. Even as he's cried poverty, he's been, living on the hog. So there's a separate discussion of the Madison Avenue co-op. Co-ops are actually, you own shares in them. And so the court orders the immediate turnover and receivership of Giuliani's 1,430 shares. They're put into receivership so they can be sold in the most profitable way, because it's a special kind of market. Ditto, now he deals with the campaign fee claim and says, that goes to the plaintiffs also. Good luck in actually getting it. But nevertheless, Giuliani's argument that somehow it makes it seem that Giuliani is prosecuting his claim against the Trump campaign as opposed to against the plaintiffs. If you just give this money to them, the court says that really doesn't make a lot of sense. They would just be there as receivers. And if there's any risk of being misled, it would just come from Giuliani himself. And in any event, it's no real reason to retain the claim. So nope, the legal fees go to Moss and Freeman, and then almost all the personal property. He had asked that they not sell it because there are certain things of public interest. A watch that the president of France gave him after 9/11, and a 1980 Mercedes previously owned by Lauren Bacall, and a watch belonging to Giuliani's grandfather. And basically, Liman applies the law in a straight up, you could say hard-hearted way, but it's a straight up way. First, Giuliani didn't seek a stay of the sale of his assets to satisfy the judgment. He could have done that by posting a bond. He didn't do it. So he didn't post a bond. Instead, he went for bankruptcy, and that action's now dismissed. So it's just, Moss and Freeman versus Giuliani. Here's the piece of paper, and they can enforce it. And there are just not many bases in federal or state law for exempting it. Certain really essentials for living, like stoves and heat and a cell phone, necessities for living, the New York law exempts, but not emotional keepsakes or mementos. A wedding ring, yes. An art that costs less than $1,000. But basically, the Giuliani has to show that these things are exempt and they come under the provisions. He hasn't shown it. And I just want to finish by reading Liman's discussion of the watch, his grandfather's watch. The watch may be distinctive to defendant as an item of sentimental value, but it is not distinctive to the law. It would be exempt if he proved that the total value did not exceed $1,000. If you say they're real sentimental keepsakes, but they're really just sentiment, not value to you, there's a possibility. But he didn't do it. However painful the circumstances, a party cannot claim that every family heirloom should be exempt from the procedures of Article 52. Otherwise, judgment enforcement would become ineffective as to all things like intergenerational wealth, like jewelry and real property. The watch, therefore, must be turned over. And everything else, all these other watches, sports memorabilia, signed Joe DiMaggio shirt, etc. He says they're unique or collectible, but it doesn't matter. They may be unique to Giuliani. That doesn't mean he can withhold them from Moss and Freeman. So the hammers really come down. 7 days, they have to be transferred or they'll just be seized. He can try and appeal to the Second Circuit, but I don't see it succeeding, especially with Judge Liman's the highly respected Judge Liman's very thorough opinion. So seems to me it's been a long road unfairly, but it's the end of the road, except for the Palm Beach condo and one or two little things. But Moss and Freeman get substantial justice and get it from directly Giuliani, who just has to turn over all his property and interests, starting with his Madison Avenue luxury co-op, to the two election workers just doing their jobs, whom he totally defamed and then acted like a rogue and not trying even to defend the case and to try to bob and weave. Law grinds slowly, but it grinds fine, and I think it has ground Giuliani to dust here, and it's just a matter of 7 days. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.